element here, the fourth element here. The fourth element here is non-natural use of the land. The fourth element is non-natural use of the land. Okay, what do you mean by non-natural use of the land? Okay, what do you mean by that? Yeah, N-O-N, non-natural, N-A-T-U-R-A-L, non-natural use of the land. What do you mean by that? Yeah, the defendant will only be liable. The defendant will only be liable if in bringing, the defendant will only be liable if the defendant will only be liable if in bringing or accumulating the thing into his land, or accumulating the thing onto his land, he makes a non-natural use of the land. He makes non-natural use of the land. Okay, what do you mean by that? What do you mean by that? What's your understanding? The defendant will only be liable if in bringing or accumulating the things into his land, he makes non-natural use of the land. What do you mean by that? That means, yeah, what do you mean by this? Yeah, it must be some special use bringing, take down this, yeah, it must be some special use bringing with it increased danger to others, and must not merely be the ordinary use of the land or such.
Teacher,
Uh,
can you repeat again and please talk
okay,
a bit
okay,
slower?
okay. That means, yeah, what do you mean by the non-natural use of this land? Yeah, the non-natural use of the land. Yeah, a judge. Okay, I'll repeat again. Yeah, a judge in the case of rickets, RICKARDS. In the case of rickets, RICKARDS, versus Lothian, LOTHIAN. Okay, in this case, yeah, in this case, rickets versus Lothian, yeah, the judge has given or explained what you mean by non-natural use of the land. Okay, what he's saying, yeah, he says it must be some special, it must be some special use, it must be some special use, bringing with it, bringing with it increased danger, increased danger to others, and must not merely be the ordinary use of the land, must not merely be the ordinary use of the land, or such a use, or such a use has is proper for the general benefit of the community. Are you following? So that means, yeah, what they are trying to imply here, if you are bringing, if you are using the land for not for non-natural use here, that means you are using the land for other than the purpose for which generally people use it. So that means you are using the land for extraordinary purposes. You are using the land for extraordinary purposes. For extraordinary purposes, then you are liable. Then you are liable. So if you're using that land generally for what people use the land for, everyone use the land for that purpose. But you are using the land for something which is extraordinary where normal people would not use it. And if it can cause harm to the neighboring land or to the neighboring people, then you are liable because you are using the land for natural use of the non-natural use of the land. Then you are liable. Are you following here? Okay, I give you one. Okay, I give you one Malaysian case here. Take down this case. I'll give you the facts also, maybe to get a better view. Yeah, Yat Yong Hong Company Limited. Yat YAT. Yat Yong Yuan YUEN. Hong HONG Company Limited. Company Limited versus Sheridan Lear and others versus Sheridan Lear SHERIDANLEA and another. That means more than one defendant. Yeah, you got it? Hello?
Yes.
You got it? Yeah. Okay. Now you see, in this case, this is an appeal case here. That's why we use the word appellant. Who's the appellant in this case? Who's the appellant? Who's the appellant in this case? Okay, hello. You see, I told you right just now. You remember just now one student, Yong Wen Bin, asked me a question. Sir, how initially the name was different and then when the defendant became different, how? In this case here, any person who's appealing a case, any person who's appealing the case to a higher court will be called the appellant. His name will appear the first name, and the person who's responding to the appeal will become the respondent, will become the defendant. So in this case, Yat Yong Hong is the appellant. He's the person who appealed. So that means here, maybe he has lost the case in the lower court and he's unhappy with the decision, he's appealing to the next court higher. Whereas Sherry Delania would have won the case in the lower court and he become the respondent in an upper court. Are you following?
Yes.
Please get this right. Yeah. Okay. Now I'll give you the facts of this case. Yeah. Take down I'll go very slowly. Yeah. The appellant. So the appellant here is Yat Yong Hong, right? The appellant were developing their land. The appellant were developing their land, which was adjacent to the respondent's land. The appellant were developing their land, which was adjacent to the respondent's land. Got it?
Yes.
Okay. The appellant's land was situated. The appellant's land was situated on higher ground. The appellant's land was situated on higher ground than the respondent's land. So that means yeah, the appellant's land were higher than the respondent's land. That means the respondent's land were on the lower ground. Got it? Some earth fell onto the respondent's land. So that means here from the appellant's land, some earth fell into the respondent's land because the respondent's land was in the lower place, am I right? And damaged the respondent's nursery. And damaged the respondent's nursery. You got it? The court held that piling, piling, loose earth on a steep slope so that more land would be available was non-natural use of land. Was non-natural use of land. You see, what happened here? The appellant's land is higher. The respondent's land was in a lower ground. So what the appellant did here, since his land is on the up, he put up some wall here to make the land bigger. But the soil from there fell into the defendant's, into the respondent's land, So obviously, he was using the land for a, that means here the appellant were using the land for natural use. So that means he's trying to make his land bigger by putting up a wall, and spreading that piece of land a bit bigger. But in the process, the soil fell into the neighboring land, that is the respondent's land, which is lower right, and damaged his nursery. So here the judge said the appellant is responsible because he has extended his land, that is non-natural use of land. Are you following?
Yes.
So that are the things you can use to save so the moment you use your land for non-natural use here, that means you're going against the normal for what people use it. Normally people won't use it for that purpose, but you are using it for something which is extraordinary. Then it becomes non-natural use of the land. Non-natural use of the land. Yeah. Okay, dapat? Okay, that cases you can use it. Or I give you one more case. You can do some work on this case. Yeah, go and do some work here. Abdul Rashid, another versus Jurusan Malaysia Consultants. You got it? The full citation, yeah. Dr. Abdul Hamid Abdul Rashid. Dr. Abdul Hamid Abdul Rashid, another versus Jurusan Malaysia Consultant and others. Go and do some work on that case. Okay, that is the four main elements, am I right? But you can add in another element here, the fifth element here, forcibility of damage. Forcibility of damage. F-O-R-E. F-O-R-E-S-E-E-A-B-I-L-I-T-Y of damage. Forcibility of damage. Forcibility of damage. You got it? Hello?
Yes, yes.
Okay. Okay. Now let me explain what you mean by forcibility damage here. A defendant will not be liable. A defendant will not be liable for all the consequential damages. A defendant will not be liable for all consequential damage that result from an escape. A defendant will not be liable for all consequential damages. Consequential, C-O-N-S-E-Q-U-E-N-T-I-A-L. A defendant will not be liable for all consequential damage that results from an escape. Okay, so that means here the concept of reasonable and foreseeable damage. So that means here, what do you mean by this? Yeah, do you know what you mean by this? You remember? So that means here, it must be reasonably foreseeable. It must be reasonably foreseeable. If we do this thing, it will harm the neighboring land. Only then he would be liable. It could reasonably foresee. If you do some act, you know it's going to cause harm to your neighbor, then you are liable. It must be reasonably foreseeable. You remember the case, the Donahue and Stephen case? You remember the ginger beer case Can you all recall the case? Hello?
Yes.
The Ginger Beer case, right? Okay, in that case here, the leading judge was Lord Atkin, right? You remember in that case, the leading judge was Lord Atkin. Remember in that case, the leading judge was Lord Atkin. You remember the judge during the case time, he did mention, right? Do you owe a duty of care towards your neighbor? Do you owe a duty of care towards your neighbor? So what the judge said that you only owe a duty of care towards your neighbor, provided you do an act which is unreasonable in your place. If that unreasonable act could harm your neighbor, then you are answerable to your neighbor if anything goes wrong. Am I right? So the same thing applies here. The possibility test is saying if the defendant knew that by him doing an act which is going to cause some harm to the neighbor, then he owes a duty of care towards the neighbor. If anything goes wrong or if the neighbor suffered any loss, then he is answerable. That is what you mean by the possibility of damage. Possibility of damage. Dapat. So these are the elements needed to establish for the by the plaintiff in order for the plaintiff to claim from the defendant under the rule in Ryland and Fletcher. Okay, so that are the rules here, the 5 rules you need to establish here. Now, of course, there will be some defenses for the defendant. Am I right? Yes or no? Hello? So now we are talking about the defenses which is available to the defendant. Of course, the defendant will say, hey, I have a defense also to defend myself. Am I right? Okay. One of the defense is consent. One of the defense is consent. What do you mean by consent? What do you mean by consent? One of the defense is consent. Consent of the plaintiff. So that means here, the plaintiff already has given express permission for the defendant to do something, and the defendant relied on the consent given by the plaintiff. If any loss or damage suffered by the plaintiff, then the defendant is not liable. You know why? Because the plaintiff already given approval, or he has already given a consent for the defendant to carry out certain work or duty. And while he's carrying out that duty or work, if the plaintiff suffered any loss, then the defendant is not liable because the plaintiff already given his consent. Are you following? Hello? Hello?
Yes. Yes, trying.
Okay, I give you a case here. I give you one case for this for consent here. Sheikh Amin bin Saleh. Sheikh, Sheikh. Sheikh Amin bin Saleh versus Chop, Chop, Chop Hup, Hup, Seng, Seng.
Can you repeat again?
Sheikh, yeah, Sheikh, Sheikh Amin, Amin, bin Saleh versus Chop, Chop, Hup, Hup, Seng, Seng. Are you following?
Yes.
So this case touches on consent. What happened in this case here? The plaintiff. Who's the plaintiff? Who's the plaintiff in this case? Hello?
Sheikh Amin.
Sheikh. Okay, Sheikh. Yeah, Sheikh is the plaintiff and Chop is the defendant. Am I right? Okay. So if you see the word plaintiff here, then you know it is the first instance case. Only appeal cases you would see the word appellant and respondent. That's where the name changes. Okay. In this case here, the plaintiff owned a piece of land. In this case, the plaintiff owned a piece of land he owned a piece of land. On that land, on which he built 8 terrace houses. So the plaintiff owned that land, and in that land he built 8 terrace houses. 8 terrace houses was built in the land. 4 of the terrace houses were rented by the defendant. 4 terrace houses were rented by the defendant. Okay, so let me share. Sheikh, he had a piece of land. He built 8 terrace houses there. 4 of that houses he rent out to Chok Hang Seng. Okay, the defendant used their rented premises for the purpose of bakery. So they used that rented house, yeah. They used the premises for a bakery. A bakery, that means you have to convert that house into a bakery. A fact known by the plaintiff. So the plaintiff knew about it. The plaintiff knew that the defendant is using the house as a bakery. You know what's bakery, right? Hello? Hello?
Yes, yes.
Okay. So he knew, that the defendant was using the houses, the 4 houses he rented, as a bakery. A fire caused by the defendant. Negligence destroyed all the 8 houses. Okay. A fire caused by the defendant's negligence destroyed all the 8 houses. The court found on the evidence that the plaintiff assented or acquiesced the use of the defendant's premises. So that means, yeah.
Slow a bit.
So
Cannot
that
catch
means, okay. I'll just tell you what happened. The outcome of the court is, yeah. The judge said the plaintiff knew that the defendant is using that particular house not for living, but for commercial use as a bakery. Am I right? He knew about it. So that means indirectly he have given consent, and you also know what is the risk involved converting that 4 houses into a bakery. He knew that it can cause harm to the other 4 houses. Am I right? He knew, because he shouldn't have allowed it to use for commercial use. Supposed to be only for residential use. Am I right? But he has allowed it. So now he has to take the risk. So you cannot blame the defendant for that, because he has given a consent to use it for commercial use as a bakery. So he cannot turn around and say no, because you use it for bakery purpose. That's why these 4 houses are also burnt down. But you have to take the risk. You knew about it and you allow it. Are you following? Hello? So
Yes.
it becomes a defense for the defendant. It becomes a defense for the defendant. That is one of the main defense, yeah. Another defense you can say, this defense all we are talking for the defendant, yeah. This all for the defense for the defendant. The other one is act of third party. Act of third party. Act of third party. If let's say a third party has caused damage, then the defendant cannot be held liable. Then the defendant cannot be held liable because it is caused by a third party, because it is beyond the control of the defendant. Am I right? It is beyond the control of the defendant. So a third party has caused damage to the plaintiff. So here you cannot make the defendant liable. So it becomes a defense for the defendant because it is outside the control of the defendant. Am I right? Are you following? So that will become also a defense for the defendant. It becomes a defense for the defendant. Other than that, yeah, another defense you can also say that the plaintiff's default. The plaintiff's default is also a defense. The plaintiff's default. That means, yeah, mistake is done by the plaintiff. So that means here you can talk about, so that means here damage has taken place, but not solely by the defendant itself. The fault also lies on the plaintiff. So that means here we talk about contributory negligence. You know what's contributory negligence, right? Contributory negligence. Pernah dengar tak contributory negligence? Contributory negligence comes under Section 12, subsection 1 of the Civil Law Act 1956. So that means, yeah, the defendant is liable. At the same time, the plaintiff also contributed towards the loss or damage. The plaintiff also contributed. So that means here, if let's say the loss suffered by the plaintiff is 100,000, okay, suffered, the total loss is 100,000. The loss contributed by the defendant is 60,000, and the loss contributed by the plaintiff is 40,000. So what the judge will do, minus off the 40,000 which is caused by the plaintiff, and pay the plaintiff the 60,000 which the defendant has contributed. That is what we mean by contributory negligence. So that means here, the mistake is on the defendant. At the same time, the fault is also on the plaintiff. The plaintiff also contributed towards the loss or the damage. Whichever percentage the plaintiff has contributed, the judge will minus of that, and only balance will be paid to the plaintiff. Because why should the defendant pay for whatever loss or damage contributed by the plaintiff? Am I right? So it's also this, you call it as a partial defense, not a full defense, but a partial defense. Contributory negligence comes under Section 12, subsection 1 of the Civil Law Act 1956 of Malaysia. Understand? You got it or not? Hello? Hello?
Yes.
That is what you mean by contributory negligence, yeah? And then other than that, yeah, what else can you talk about here? These are some of the main defenses which is available for the defendant. Okay. So, of course, you all know who may sue. Normally, only the plaintiff will be suing, am I right? Normally, the plaintiff will sue, am I right? So, that are the things which you need to know on rules in Ryland and Fletcher. If you run through the slides here, you would know, you will get a clearer picture here. And also, I've given you all a tutorial question. Okay, why, you see here, how come you are not submitting any of your tutorial question in your Moodle here? Mengapa ya? Hello, class rep.
Yes, I submitted one. Others are still doing.
Today.
Yeah.
In the Moodle, yeah, in the Moodle.
Yeah, already submit one.
Okay, let me check and I will go through here. Okay. If at all you all having a midterm exam here, so you all need to know, explain what you mean by strict liability, the definition of what you mean by strict liability, and then go on to explain this strict liability was laid down in the case of Ryland and Fletcher, and then you give briefly what happened, the facts of the case, and then you say what are the rules or what are the elements needed to establish to make the defendant liable. To make the defendant liable by the plaintiff, am I right? What are the elements needed? You explain all the 5 elements, and then you also talk very briefly what are the defense available to the defendant. What are the defense available to the defendant? And please go through some of the cases which I go in there to put it in your answer. Are you following? Hello?
Yes. So this is for what? This is for our tutorial or what?
I think this is the tutorial question also like given you all. And And
Okay.
hello, and also if at all, if you're having a midterm exam, it should be centered around here. Hopefully. But I don't think so. You're having a midterm exam. I don't think so. But anyway, I told you all I will let you all know on Monday, right? Okay, now,
Yes.
okay, now, what time shall we have a class on Monday? Or shall we make it like this here? Shall we make it like this? Okay, next Thursday, are you all having a class? If it's exam week, then it's no class, am I right?
If it's exam the study week
If it's exam, then it's a study week. If there's no exam, then class as usual, am I right?
Yes.
So then what we'll do here, Monday, maybe tomorrow, yeah, or tomorrow, I will know whether you're having a midterm exam or not. If listen carefully, yeah, if you're having midterm exam, if you're having midterm exam, then what I will do, I will have a class for you all on Monday. I'll have a class with you all on Monday. If you all having a midterm exam next week, because I wanted to uh, do one area on environment law. Environment law. Okay. If there is no midterm exam next week, then we are not going to have a class on Monday, but we'll have the class as usual on Thursday. So I can only confirm it tomorrow. If confirm that you're having a midterm exam, then Monday I will have a class with you. Okay, Monday means what time? So Monday you all don't have any classes, right?
Yeah, we didn't have any classes.
So that can we have it like our normal time, 11 to 1, or you all want to have it in the evening?
I'm good with it.
All of you are okay with it, 11 to 1? Hello?
Yeah, okay.
Okay. So if okay, this only will have class only on Monday, provided you are having a midterm exam next week. If
Okay.
if I knew that there is no midterm exam, then we are not having a class on Monday. We'll have our normal class on Thursday. Okay.
Okay.
Okay. Now, the rest. Okay. Now, please, yeah. Please, yeah. I hope all of y'all do the tutorial questions, yeah, and submit. You know why? You know why I'm telling you all here. You know why this is important. If let's say, yeah, if in your exam, yeah, if you all did very badly, if you all did very badly in your exam, yeah, let's say, yeah, then this would come to help you all, then this will come to help you all. That is the reason why I want you all to do the tutorial question, because that will come in to help you all to what do you call that, to balance out. Then I will take into consideration your what do you call that, your whatever assignment which you have done, yeah, to help you all out, Are you following? That is the reason why I wanted you all to uh, do it. But you see here, another thing here, if you all are going to have, if you all are going to have, uh, not going to have your midterm exam, yeah, then you all will have two assignments to do. Two assignments to do. The two assignments here, which I've already set, two individual assignments, each 3,500 words, each 3,500 words. So that means two individual assignments, which I've already set the questions for you all. Then, if that's the case, I will let you all know in due time on what are the areas you all need to focus on for that assignment. And also, I will guide you all on how to go about it also. Okay, Shelly, are you all?
Yes. Okay.
So tomorrow, maybe I will communicate with you all to say what is the status. All right. And then we will do what is necessary.
Okay.
To my understanding, looks likely you all are not going to have your midterm exam. Looks likely, but only tomorrow I will confirm it. All right. Okay. Now, whatever is here, I'm trying to see here. Now, listen carefully here. Whichever areas you have, even though you listen here, even though you are not going to have your midterm exam here, but you will have an alternative exam. That exam is different. I've also set questions for that already. It's a bit different from your actual final exam, because your actual final exam you don't have any assignments to do, right? But if the MCO keeps on going, then you will have 2 individual assignments to do and a short test. For that also I've already set the question for you all, and I will also focus on that area if it's necessary. I'll tell you. Okay. Okay, any other question, please? Any other question? Any other question, please?
No.
Tak ada ke? Sure. No question?
No.
Betul, lah. Okay, kalau tak ada, I will keep in touch with you all tomorrow and then we'll do a follow-up tomorrow. Okay,
Okay.
now I can see Joshua's name suddenly appeared, huh? Joshua is, I think he came in late, but he's in Joshua is there now, I think. Yeah. Okay, never mind. I will try to call you all tomorrow, yeah? All right? So
Okay.
try to do the tutorial questions and submit, yeah, please, yeah? It will be helpful for you. Okay, bye.
Thank you.
Bye. 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 Bye.